We are here in the case of State of Ohio versus Tyrone Merritt, case number 24-CR-970. Defendant is present in the courtroom, represented by defense counsel William Watson. On previous date, the defendant pled guilty to an amended count 1, attempt to commit felonious assault, felony of the 3rd degree. We are here today for a sentencing in the case.
Okay, pause. Hear this. Isn't your average court day. We've got a man charged with attempted felonious assault, a co-defendant, a baby shower gone wild, and a victim who ends up in a coma. Stick around, because this case turns fast, and it gets ugly.
Thank you. Mr. Watson, any reason not to go forward with sentencing?
No, Your Honor.
Anything you'd like to say on behalf of your client?
Thank you, Your Honor. May it please the court. I'm going to be brief. I'm not going to repeat everything we had discussions in chambers about, but my client is a man with, I believe, some anger management issues. And on this day, there was a party, a baby shower, for my client's friend, who was a co-defendant in this case. The co-defendant was the father of this child, and my client went along to this party. And there was some animosity, some friction, some anger between the co-defendant and the mother of the child and the mother's family. And that friction spilled out outside. And my client, who was, I believe, at a moment sitting in a car, lost his temper, got out of the car, ripped his shirt off, and tried to jump into a fight with various people. The victim in this matter, who really had nothing to do with anything, got in between my client and I believe a woman, and there were some other people nearby, and the victim was then punched from behind by the co-defendant. Now that punch, according to a lot of the witnesses that were there, very well may have knocked out the victim in this case.
Let's unpack that. Merritt's punch wasn't just a follow-up, it came after the victim was already falling, possibly unconscious. In legal terms, this matters. Even one punch can tip the scales between assault and life-altering injury, and the court definitely takes that seriously.
But as he was falling down to the ground, my client then got on top of him and threw his own punch. The victim, as the court I know is well aware, suffered some extremely serious injuries because of this. He was in a coma, and I believe has lifelong injuries as a result of this. My client is extremely remorseful for his conduct that day. He has told me on numerous occasions if he could take back his part in it, that he would. He's really been at a loss of words with regards to what to do or how to handle things. He's taken responsibility for his part in this case while he's been out on bond, and I know this case has dragged on a little longer. I know there was private counsel for a period of time, but during that whole time, he has not picked up any other cases. He was, when this incident happened, he was on probation out of Cuyahoga County, but he has successfully completed. I know the court's aware of that. In fact, I do have a certificate here stating as such that he completed probation out there. He's showing up to every court appearance. He participated with the pre-sentence report, and up until very recently, Your Honor, he was employed full-time. Now, the only reason he left the job, and he left voluntarily, wasn't due to anything bad that he did. He just felt that this was a good job, and he wanted to leave on good terms, and if, in fact, there was any jail or prison time involved with the sentence, he didn't want to just leave this job hanging. However, they told him that if he does get probation, and you can hear from him in just a moment, but if he does get probation, he's more than welcome back. So technically, he does have a job if the court will consider a community control sanction. I'm going to respectfully ask the court to do just that, consider community control, give my client an opportunity to show this court that he can be a law-abiding citizen. If the court wants to put whatever restrictions on that, I would again maybe suggest anger management classes. But let the court put restrictions on. Let my client show the court that he can do what needs to be done, and he can be a good person, and he can be a good citizen. I'm respectfully asking the court to give him that opportunity. And again, you're going to hear from him just now, Your Honor, but he is extremely remorseful. Thank you.
Let's unpack that. Merritt's punch wasn't just a follow-up. Came after the victim was already falling, possibly unconscious. In legal terms, this matters. Even one punch can tip the scales between assault and life-altering injury. And the court definitely takes that seriously.
Your Honor.
Thank you. Mr. Merritt, you have the right to address the court before your sentence. You can say anything you'd like. Is there anything you want to say at this time?
Yes, sir.
Go ahead.
I want to say, to Deshaun, I want to apologize to him and let him know that what I did was wrong, and if I could, I'd take it back, and I would go by things different. And I want to ask the court, can I get probation to show that I can handle probation, and I feel I do need anger management classes, and on that day I lost my cool, and I just want to show that I can be a better man. That's all.
Thank you, sir. Mr. Watson, anything else?
No, Your Honor.
The state of Ohio, Mr. Gretzky.
Thank you, Aaron. State recommends prison. On that day, the defendant escalated it into a physical fight situation. He took his shirt off, went in the parking lot, said, "I'll take any one of you," and he stepped towards a woman who was not involved in the fight. And then the victim, her brother, intervened, stepped in front of her. He also had nothing to do with any of the, when I say fight, the argument that preceded all this. The victim was blindsided, punched by the co-defendant here, and on his way down, punched by the defendant. He hit his head on the concrete, and the defendant, co-defendant, and everyone they came with left the scene, left him there. No concern for him. He was in a coma for...
And here's the gut punch. A 3-month coma, facial fractures. Permanent brain trauma all from a fight the victim wasn't even involved in. The prosecutor's message is crystal clear. Walking away wasn't just an option, it was the right one. But no one did.
3 months. He suffered serious brain injury, multiple fractures. He had facial fractures, and he fractured his teeth, his front teeth as well. Will continue to have injuries or threat of more severe injuries for the rest of his life due to this incident, and he's only in his early 30s. The defendant at the time that this occurred was on probation, and previous to that had been to prison for an offense of violence. For all these reasons, the state believes that prison is the appropriate sentence in this case.
Thank you. This court reviewed the pre-sentence report and investigation. I've considered the facts and circumstances of the offense involved and the nature of the offense. I've considered what's been said here in court. Mr. Watson, the defendant himself, the prosecutor, recommendations from the parties. All of this is considered by the court in light of the purposes and principles of felony sentencing set forth in 29-29-11. As for the factors in 29-29-12, factors indicating the conduct is more or less serious, the court notes that the victim in this case suffered serious physical and psychological harm as a result of the conduct, while the offense itself deals with serious physical harm suffered by the victim and caused by the defendant's conduct in this incident is much more serious than we normally see in a felonious assault. First of all, felonious assault could be just getting cut and having a scar, which is considered permanent. But even beyond that, the injuries suffered here were much, much more serious than what we normally have for a felonious assault or attempted felonious assault. And the victim, as alluded to, suffered serious brain injuries and a coma for 3 months. He's still experiencing symptoms and trauma as a result of this incident. He's going to experience seizures perhaps for the rest of his life even as a result of this. Doesn't know when they come on, but they do come on. All because the defendant decided to inject himself into this incident that was occurring that he had nothing to do with. The victim in this case was completely innocent, had nothing to do with whatever was going on that caused this arguing to take place. And the defendant gets out of the car, challenges anyone who wants to fight. Steps by near a female, so the victim, steps in front of her, it's his own sister, and then takes the brunt of this beating. So the conduct itself and the nature of the serious physical harm makes it much more serious than we normally see for this type of offense. Nothing makes it less serious. As for recidivism factors, the court notes the defendant was on probation at the time he committed this offense to Cuyahoga County. He has a criminal history, which includes a prison term that he served for a robbery charge back in 2010. So the conviction was served his sentence in 2011-12. Has not responded favorably to previously imposed sanctions. No factors indicate recidivism is less likely. It's only a third degree, so no factor. There's no presumptions one way or the other. Considering the appropriate sentence, there's just no way this court could ignore the extent of the victim's injuries here and what happened to this victim and what he's going to have to experience and suffer for the rest of his life. For nothing. The court finds prisons consistent with the purposes and principles of sentencing. The defendant's not amenable to available community control sanctions. Therefore, it will be the sentence of
30 months? That's 2.5 years in prison? Was it too harsh? Too lenient? Consider the lifelong injuries, the prior criminal history, and the fact that this all happened while Merritt was already on probation. Let me know your tack because this sentence is going to stir opinions.
this court that on the lesser included offense of count one, defendant served a term in prison of 30 months. He has credit for 4 days he's already served. I need to advise you upon your release from prison, you will be placed on post-release control for at least 1 year. It could be up to 3 years. That's up to the parole authority to determine. When on post-release control, if you're violating their conditions or supervision, the parole authority can return you to prison as punishment for violating the rules for another 9 months for each violation you commit, up to an overall maximum of 50% or half the term I just imposed. Any additional prison term imposed for violating post-release control is being imposed as part of the sentence at this time. Defendant's ordered to pay all costs incurred in this action. The court hereby releases the bond. Mr. Gretzky, is there anything else for the record?
No, Your Honor.
Mr. Watson.
Nothing further.
All right.
Tyrone, how much money? I'm gonna see you Wednesday, okay? You're gonna be in contact for a little bit. You know,